We'll kickstart this session with the paper to be delivered by Paul, entitled Sports Arbitration Essentials, the Practitioner's Kit Bag. But firstly, just a few words of introduction of Paul, and it's indeed a privilege to see Paul back here in KL, here in this auditorium, to deliver a sports law paper. Paul Hayes is a barrister, an arbitrator, and holds degrees from the Bachelor of Laws from Queensland University, as well as a Master's of Studies from the University of Cambridge, where he was also a visiting fellow in 2005, in the years 2005-2006. He also holds and is also a fellow of the Chartered Institute of Arbitrators. Paul was called to the bar in Australia, New South Wales, in 1990, as well as in England, where he is a member of the Honourable Society of Lincoln's Inn. That was in 2005. He's a member of 39 Essex Street Chambers, and also practices in Australia as a member of a Divas List in Melbourne. Prior to commencing practice at the bar, Paul worked as a lawyer in Sydney with Allens as well as Baker and McKenzie. So without much further ado, if I could invite Mr. Paul Hayes to the stage to deliver his paper. Paul.
Thank you very much. Your Royal Highness Tunku Imran, members of the KLIAW, fellow colleagues. Firstly, I'd like to thank the KLIAW for imbuing upon me the considerable privilege of inviting me to come here and speak at this conference. I consider it an honour and a privilege to be here, and certainly it's even more enhanced given the esteemed company I'm in with Tunku Imran, Chris Anderson, our session being expertly facilitated by Richard Wee. That's indeed a very humbling experience. The topic for this morning's address, Sports Arbitration Essentials, the Practitioner's Kit Bag. What inspired me was for this topic was in fact the rubric of the session, the mechanics of sports arbitration. And it's one of those things where many people profess to know about sporting disputes or sports arbitration, but they know a bit about them. And there's often a reluctance for people to come forward and, I suppose, express what they don't know about dealing in this area, and it's understandable, because it's a very narrow area of practice, but it's one which is growing rapidly. And so the purpose of this morning is to perhaps pass on the benefit of some of my experience in this area gained over the last decade and a half almost, and appearing in close to 50 CAS arbitrations. And in the immortal words of Socrates, experience is the name everyone puts down to their mistakes. I've made plenty, so far better for you to learn from my mistakes than from your own, hence the topic of this morning's address. This morning's address is going to deal with 6 topics, which I'll move through hopefully briefly. Firstly, we're going to start with the nature of sports arbitration, the sporting contract, and sporting disputes. Next, we're going to look at the difference between domestic tribunals and arbitration. This is a critical distinction to make, and often people conflate the two when considering the means by which sporting disputes are resolved. It's even more important to understand that distinction in light of the exciting new developments that have been flagged by Tunku Imran, with MSAT on the horizon and hopefully coming to fruition within the next year. Thirdly, a background on the Court of Arbitration for Sport. Fourthly, this is where I've made plenty of mistakes. CAS procedural considerations, and there are many traps for new players which can grab you quite surprisingly, and as I've been caught by surprise on a number of occasions, we'll deal with some of the traps and tricks in that area of practice. Thirdly, all very well to practice in the area and understand the mechanics and means of practicing in the area of sports arbitration, but whereabouts do you find the law? Whereabouts are the resources for this area of practice? Well, we'll deal with that in section 5 of this morning's address. And then finally, after you've expertly managed and run your CAS arbitration or your sports arbitration, and you've notwithstanding the fact that you gave it a great run, you've lost. What are the means by which you can challenge the enforcement of the award? Now, I'm certainly not encouraging that, but it's an area of practice which has enlivened the interest and jurisdiction of the Swiss Federal Tribunal, especially in the last 3 to 4 years. So they're the 6 areas of this morning's address. Turning, before we embark upon that, what you'll see there, for those who will get a hard copy of my presentation, forgive me if sports lawyers and sports arbitration practitioners sound as though they're speaking a rather exotic dialect of Swahili, given that many of the acronyms used in this area would make even the most determined officer within the Pentagon seem rather meek by comparison, given some of the analyses, not just in sports arbitration, but especially if you're involved in anything to do with the Olympic movement. In fact, I think the Olympic movement would probably trump the Pentagon when it comes to acronyms and the like. Turning to our first topic, why sports arbitration? Well, in particular, picking up on the thread of Tunku Imran's address this morning, it's really emerged in the last 30 years, so it's a new area of practice. For many here, it's not the sort of area that's going to be traversed in law school because it's relatively new, and so it takes time for there to be built up a body of academic and professional experience so that this new discipline can emerge, and we'll go about defining this new discipline in a moment. But certainly, the reason it has developed in the last 30 to 35 years is due to 2 criteria. Firstly, professionalisation. Think about this. The Olympic movement, which sets the tone for all international sport, whether it's American football, Australian football, Gaelic football, or anything else, the Olympic movement and the Olympic Games is the biggest show, biggest sporting show on earth. I think Benoit might disagree with me when it comes to the World Cup representing FIFA. But by and large, it's the one that captures the world's population or the imagination of the world's population. In 1984, something very interesting happened. Let me step back from 1984, though. And who remembers, without giving up your age too much, the 1976 Olympics in Montreal, which was completed in a half-finished stadium? The cost of the Olympic Games to the city of Montreal and also to Canada was an enormous financial imposition. And up until that point in time, government had largely absorbed the cost. So in other words, it was an honour for the city to host the Olympics, and the government of the state of that city would wear the cost of those Olympics. 1980, the Olympic movement was in a little bit of trouble over the boycott of Moscow. Again, the state absorbed the cost of the games in Moscow. One will never be truly clear how much was spent or not spent on the games in Moscow, but again, state cost. And then something very interesting happened in 1984. In 1984, the president of LOCOG, or the head of LOCOG, was Peter Ueberroth. Mr. Ueberroth had previously been the head of the National Baseball League in the United States, so he had come from a professional sports background. And Peter Ueberroth softly introduced what we call soft commercialism to the Olympic Games, because such was the weight of the cost of putting on the show which the IOC, the 115 members of this private institution, and it's important to understand that it is a private event because in the context of sports contracts, the very juridical nature of participation in sport, and hence sporting disputes, is that it comes from the private law of contract, is charged under its own charter, the IOC, to put on the Olympic Games every 4 years. And so the Olympic Committee, the IOC, needs the support of states in order to stage what had become the Olympic Games. However, states were reluctant to buy in because of the cost of Montreal, because of the political cost and risk of what happened in Moscow in 1980, the African boycotts again in 76, and the Eastern Bloc boycott again in 1984. So we see soft commercialism arriving in Los Angeles when LOCOG put on the Games in 1984. And the outcome of that was that the Los Angeles Olympics delivered a profit in 1984. There was only one Olympic Games in the modern era, up until 1984, which had delivered a profit. And that was Los Angeles in 1932, coincidentally. So all of a sudden, what you have is the Olympic movement itself to put on the Games is suddenly, just softly, getting involved with commercialisation. On top of that, we see the rise of television in the 1970s and into the 1980s, colour television especially, certainly in Australia, certainly in Europe, and certainly in Asia, came to life in the 1970s. And so suddenly, people are watching the Games as much on television as they are digesting it in any other form. It was during the 80s that we saw the ultimate erosion of amateurism. So, 1989, essentially, all of the international... By 1989, after the Seoul Olympics, most of the international federations that conduct Olympic sports that are in the Olympic program, by 1989, had pretty well accepted the fact that professionals could compete, as had the International Olympic Committee. So, by the end of... by 1989, you've got Olympics now being profitable. You've got the end of amateurism. As Tunku Imran says, there's more money, which is what drives there being more at stake in terms of sporting disputes. So there's no accident or no coincidence that in 1984 the Court of Arbitration for Sport came to light against this backdrop of increasing internationalisation and professionalism, which is why this area that we hear about today is relatively new. So like most good lawyers, following the money, that's how we now practice. That's how we now practice in sports law and sports arbitration. And very eloquently summed up by Jan Paulsen, who's a member of the KAS panel and is one of the world's leading international commercial arbitration practitioners. Indeed, if you look at the KAS panel, it's an extraordinary, over 200 people from around the world. It's quite extraordinary, the level of expertise, the number of people on that panel. If you practice in the area of international commercial arbitration, it's very much the A-team of international commercial arbitration. A lot of the world's top arbitrators also happen to sit on the KAS panel, which says a lot about the importance of this area. So sports arbitration, well, what is sports arbitration? It's the private adjudication of sporting disputes, bearing in mind that it starts with a contract. It was started by the Court of Arbitration for Sport in 1984 as a consequence of the internationalisation and professionalism of sport derived by Juan Antonio Samaranch, and it determines sporting disputes which are legally binding on parties to a sporting contract. I'll pause there. Sporting contract is vital. The nature of that contract is vital in sports arbitration. How is it that the parties have created legal relations between themselves to govern the participation in sporting activity, and secondly, how those disputes are resolved in accordance with that agreement to participate. What happens with KAS, of course, is no different to any other commercial contract, because the arbitration clause, which gives KAS its jurisdiction, the separable arbitration agreement, for those of us who practice in the area of international arbitration, produces ultimately an award which is binding under the 1958 New York Convention. So when you strip it back and you look at the very nature of the rights and obligations of the parties, and when you look at the nature by means of which the parties between themselves have agreed to resolve their disputes, no different to any other form of arbitration or commercial arbitration, you'll see that this is just like any other field of international commercial arbitration. However, it's a specialist field, one which requires the input of specialist practitioners, specialist knowledge, and it has a few little specialist quirks which we'll investigate this morning. The sporting contract. Now, I've referred to Australian cases in terms of looking at the sporting contract. position in the common law world is universal, that the entire means of contractual interpretation is based upon objective perception. That proposition holds very true, not just in Australia, New Zealand, the United Kingdom, Malaysia, Singapore, Hong Kong, right throughout the common law world. What you have is a series of umbrella agreements. Now, the first task for a sports lawyer acting in a sporting dispute is to identify what is the contract. Try and identify the scope of the contract. The very nature of the contract itself might seem to be superficially simple. A membership agreement whereby the membership is brought about by a contract between the athlete or participant and the sports organisation, and there'll be the usual boilerplate provisions. But what you'll see is a provision which incorporates the rules of a national federation, the rules of an international federation, and other policies and rules of that sporting club or organisation by reference. And so it's the incorporation by reference of the rules and regulations. Very rarely will you ever, almost unheard of, will you see a membership of a sporting club or organisation whereby the member does not agree to be bound by the rules and regulations of the club, which in turn will embody and incorporate by reference all of the rules of the national, international federation and everyone else higher up the tree, which is what we call an umbrella agreement. In terms of interpreting these rules, once you've identified the scope of this contract, so you look at it and you think, all right, well, it incorporates these rules by reference. Let's have a look at the rules, see what they incorporate. What are the rules which govern the behaviour of the parties to this particular relationship? And secondly, if there is a dispute, how ought it be resolved? Sometimes there'll be provision for it to go before a domestic tribunal. In other words, the club's own judiciary committee or the national federation's own judiciary committee. It might refer the matter to the Court of Arbitration for Sport for it to be dealt with by way of arbitration. Two distinctly separate beasts, if you like, in terms of dealing with dispute resolution. But what we have is a means to which, firstly, not just the participation agreement, but also the arbitration agreement is construed. And this is a consequence of the Court of Arbitration for Sport being very unique compared to other forms of international commercial arbitration. One of the great hallmarks that attracts business people and commercial entities to arbitration is privacy and confidentiality. So if there's a fight between ExxonMobil and perhaps another entity, Halliburton or something like that over a drilling rig, the last thing either of those corporations want is their senior executives being cross-examined and having their deals unpicked apart by their opponents in open court. That's if you like, one of the touchstones of the attractiveness of international commercial arbitration, as opposed to the alternative of curial means of dispute resolution through the courts. A little bit different though in sports arbitration, because while the arbitrations are conducted privately, the awards are public, and there's a very good reason for that, because sport is predicated upon participation in sporting activity in accordance with a series of rules. And as stated by the Court of Arbitration for Sport in a decision, Quigley and the UIT, it was a shooting case handed down in 1994. It was so that the entire sport community are informed of the normative system in which they live, work and compete, and in the circumstances in which these rules apply. So that was reinforced in the decision in 2004 of the CAS, the United States Olympic Committee against the International Olympic Committee and the IAAF, the International Amateur Athletic Association, Federation, and also in the case of Anderson and USOC and IOC in 2010 and 2011 respectively. So rules are really important in sport because you can't have a sporting contest unless everyone is playing by the same set of rules. And not only is that on the pitch, but that is also off the pitch. Hence, one of the little quirks of CAS arbitration. Private hearings, whatever happens in the hearing room, remains private. But bear in mind, findings will be made and awards will be published. To understand how the contractual suite of agreements work, it's informative to look at the structure of international Olympic sport. And this goes some way towards explaining the contractual relationships between the parties. Here, in the gold medal position, is the IOC. They've got the gold. They have the show that's put on every 4 years called the Olympic Games, so they hold the cards. No different to any other commercial arrangement. Silver, the National Olympic Committee. Then over here, you have all of the international federations, national federations, local clubs, and the athlete. And these are all contractually bound. So if you're just a hack weekend athlete like myself, you're bound to all of these rules, such as the rules of the federation, including the World Anti-Doping Code, conduct policies and the like, through all of these rules and regulations of the particular sport, say it's athletics, of the International Amateur Athletic Federation Association of Athletic Federations, as it's now called, being here in the international federations, which then, if you are to be recognised as the National Athletic Federation, say in Malaysia, the Malaysian Athletics Federation have to agree to be bound by the IF's rules. If you're a club and you want to participate in athletics in Malaysia, you have to agree to be bound by the Malaysian Athletic Federation's rules. And these rules are largely influenced by the IOC. The IOC likes to keep a pretty good look in terms of governing how the international federations manage themselves, because the competition between the different sports to be included in the Olympic Games every 4 years is fierce. Sometimes sports drop in, sometimes they don't. So there's a certain degree of, if you like, I'm not saying it's improper, but collaboration between the IOCs and the IFs, where everyone's trying to make sure everyone's happy in terms of the rules and means by which people participate in the sport, and hence the Olympic Games. Now, if you're the athlete down here that's talented enough to go to an Olympic Games, you will also be bound to things like the World Anti-Doping Code, not just through your club memberships and national federation and international federation requirements, but the National Olympic Committee will also get you to sign up and agree to the World Anti-Doping Code and its own conduct policies. What these two agreements have, so you'll find the athlete who's competing at an Olympic Games is doubly bound, is that this person here is bound to WADA, the World Anti-Doping Code, which unfortunately takes up a large part of CAS activity. Still mystifies me what would motivate people to cheat through the use of performance-enhancing drugs, but they still do. And it's something that the sports movement needs to deal with. Secondly, the means by which those disputes are dealt with, namely a dispute resolution clause, assigning all of those disputes to be dealt with by CAS. So all of these clauses are passed down, and that's how ultimately the structure of Olympic sport works both politically and legally to bind the athlete to CAS. Over here, national governments, they introduce their own legislation. A good example of that is anti-doping legislation. The World Anti-Doping Code came into being in 2003. In 2005, in world record time, sponsored by UNESCO, an international convention against doping on sport was signed up where 68 countries in 2 years, almost unheard of, for those who work in public international law, to get people to not only sign up to a convention but actually get one up and running, where governments agreed to implement the legislative machinery so that anti-doping regulation could be enforced and operated in their respective domestic jurisdictions. So what are sporting disputes? Well, sport, I define it as a highly organised social activity comprising of persons voluntarily playing games in accordance with an agreed set of rules to produce an outcome which results in a winner of the game. Sporting disputes are a distinct body of regulatory and case law unique to sport, such as eligibility, in other words, which country does somebody belong to or can they compete for at an Olympic Games. We're 12 months out approximately now from the Rio Games, and these are the cases we're going to see and be much busier with in the next 12 months. There'll be eligibility cases, there will be selection cases. At the Games there'll be game rule cases. We won't go into these this morning. There'll be cases on doping, on and off-field conduct, and integrity, which is match fixing, spot betting and the like. So it's these types of cases where they're regulated by policies of international federations passed down and binding the athlete. Remember that flowchart we looked at before. And also case law, which has evolved over 30 years in the Court of Arbitration for Sport. So we have this identifiable, discrete body of jurisprudence combined of private sporting regulation, which, even though it's private, it's really public in a way, because it's brought about in such a way that federations, being semi-private entities or semi-public entities, depending on which way you look at it, all agree to be bound by a series of rules and then privately bind their participants to those rules in accordance with contracts, and then published arbitral awards at the Court of Arbitration for Sport. It's different. What are not sporting disputes are if somebody tripped over on a cricket pitch and wanted to sue the sporting club for negligence. Things like that. So causes of action in contract or tort, which you'd otherwise bring before the national courts, are not what we call sporting disputes in the context of sports arbitration. Finally, as you can see, the nature of sports law, it spans private and public, domestic and international law, but it's primarily international in character, given the dominant roles of those international bodies such as the IOC, WADA and the like, and also the case law that comes from the published CAS awards. And that's what makes it such an interesting area, because it's a challenging area. It's a multidisciplinary area, and as a sports arbitration practitioner, you need to be across both public and private law, domestic and international law. It requires the skills of a commercial lawyer in terms of analysing contracts, but in a doping dispute it requires the skills of a common law or criminal lawyer dealing with evidence that's often more at home in the criminal courts. So it requires a very broad multidisciplinary set of skills, and that's what makes it such an interesting and challenging area in which to practice. This is just to give you a bit of an idea. We're not going to go through this, but this is what the 2012 Australian Olympic Team Agreement says on dispute resolution, which through the left of those two channels of the diagram before is what binds athletes to the AOC. Athletes also agree from any National Olympic Committee to abide by the Olympic Charter, and the Olympic Charter also requires any disputes relating to the Olympic Games be dealt with by the Court of Arbitration for Sport, just as the WADA Code does. I'm not going to go into that in detail, but it gives you, you'll see that I just simply highlight it. You can read it in the published slides, but it emphasises how different this area of practice is compared to a normal dispute resolution clause than what you'd find in a multi-million-dollar agreement. The 1 second to midnight clause that's often inserted at the last minute as part of the deal, normally 1 or 2 paragraphs. These clauses dealing with dispute resolution in sport are considerably more detailed if you look at the AOC's lead, which highlights again the unique nature of this area of practice. So we come now, domestic tribunal or arbitration. Well, again, it comes down to the construction of the agreement, as we've dealt with before. And what did they agree upon? In other words, this is what requires you to pick apart the scope of the agreement. This is why it's important to see what's incorporated by reference and what isn't. And this is why it's especially important in looking at the dispute resolution provisions to see where you find through these rules and regulations that are incorporated into the agreement, where firstly you characterise the nature of the dispute and see where then that dispute resolution process under the relevant policy or rules leads you. So you might have a situation whereby a sport, say it's squash, and I don't know whether squash has this or not, but if there's a conduct dispute, somebody behaves badly, behaves like a bad sport, and the organisers of the sport say that you've breached code of conduct policy and you behave badly, and therefore you have to go before the National Disciplinary Tribunal to deal with that, and its own in-house tribunal to deal with it. That would be a domestic tribunal. But if that person had taken a performance-enhancing drug and they tested positive to that, then the nature of their conduct would be such that it would be a doping offence. And under the anti-doping policy of squash, which would incorporate all of the mandatory provisions of the World Anti-Doping Code, those mandatory provisions also require that doping offences, while it might be at first instance okay to be dealt with, before a domestic tribunal ultimately have to be dealt with before the Court of Arbitration for Sport on appeal. So if there's any appeal dealing with a doping offence, ultimately, it doesn't matter what you have at first instance, but ultimately it has to finish up before the Court of Arbitration for Sport. So that's a very good example as to why it's important to undertake that very early step, identify the scope of the contract, characterise the nature of the dispute. Raguse and Sullivan deals with the nature of international sports arbitration, likewise insofar as the nature of CAS arbitration, it's an international, not domestic arbitration, and the seat of the arbitration, CAS is permanently seated in Lausanne, is different to the place of arbitration. Recently in Australia, Justice Clyde Croft, who's the head of the arbitration list in the Victorian Supreme Court, we're very lucky to have Justice Croft in Melbourne, and the size of the arbitration list now in Melbourne speaks volumes to the growth of arbitration in that part of the world, because of having an expert judge such as Justice Croft. Dealt with it recently in the ASADA litigation, where the AFL Anti-Doping Tribunal, Australian Football, was conducting a disciplinary hearing, a first instance anti-doping hearing, after which an appeal would, so its own domestic tribunal to deal with anti-doping, from which an appeal, and I won't go into who and how had a rights of appeal, but ultimately there was a right of appeal to CAS, which conformed with the World Anti-Doping Code, but the hearing at first instance was before its own domestic tribunal. ASADA, the National Anti-Doping Regulator, was seeking to subpoena third parties who were alleged to have provided performance-enhancing drugs to 34 players of the Essendon Football Club. If it were an arbitration, a subpoena could have been issued under the relevant domestic legislation to compel those people to come to court and give evidence in ASADA's case, presumably after they were declared hostile given their reluctance. Not so, said Justice Croft, because notwithstanding the nature of this case, and there was ultimately a right of appeal to CAS, the hearing at first instance was not an arbitration. It was a hearing before a domestic tribunal. So the ancillary machinery of having subpoenas available to compel people to attend what was otherwise a private hearing under the Australian domestic arbitration legislation was not available to ASADA, hence they couldn't subpoena the relevant witnesses. It's also a very useful decision, I've got the references there, where His Honour in his usual scholarly style goes about listing what are the ingredients of a proper arbitration. The Court of Arbitration for Sport, the history, will go through this. We've dealt with a lot of it already, and Tunku Imran has very impressively and comprehensively spoken about it up until this point. Established in 1984, ICAS was founded in 1994 to guarantee the independence of CAS. The first ad hoc Olympic division was in 1996. 3 years ago to the day, as Richard highlighted, CAS set up here in Malaysia, and over 200 CAS arbitrators hear approximately, well, in fact, it's now 400 cases per year, ranging from doping to football transfer cases. Looking at its jurisdiction, again, this is why the sporting contract was so important, and I'm sorry if I might have laboured the point early, but hopefully it's now starting to come to fruition. As a sports arbitrator, as part of your kit bag, why this contractual analysis exercise at the beginning of receiving instructions is foundational towards how it is you conduct the sporting dispute. Ultimately, it comes down to a jurisdictional clause somewhere tucked away in the applicable regulation once you've characterised the nature of the dispute. CAS is permanently seated in Lausanne, which is so therefore the law of Switzerland applies as the lex arbitri, as the law of the seat, but arbitrations can be conducted worldwide, awards enforceable under the New York Convention. Post-ICAS, there have been challenges to the independence of CAS in the matters of Lazatina and Danilova, and also in Hondo and Cañas. Swiss Federal Tribunal has said, notwithstanding, threw each of those out, and again has reasserted the independence of the Court of Arbitration for Sport. And since ICAS was set up in 1994, there are three challenges. There have been others. None of them have come within a bull's roar of challenging the independence of ICAS or the CAS. Needless to say, given that the CAS is permanently seated in Switzerland. It has the residual supervisory jurisdiction over the lex arbitrae, and recently, and we'll touch upon it in a moment, hasn't been shy in trespassing on the conduct of CAS arbitrations insofar as declaring awards being unenforceable if they fail for procedural irregularity or those very narrow confines that are set out under Article 190 of the Swiss Federal Code on private international law, which permits a court to intervene to refuse to on an application for non-enforcement. In terms of the core procedure, there are two divisions. Since CAS was established, there's always been two divisions, an ordinary and an appellate jurisdiction. CAS arbitrators, you can have one or three in each arbitration, but unlike other arbitration tribunals, CAS arbitrators have to be appointed from the panel of people on the CAS panel. So you can't say, for example, like a commercial institutional arbitration, say, well, look, if there are three arbitrators, you might be running it in one of the institutional arbitrations. Say we ought to have so-and-so participate in this arbitration. CAS, they have to come from the panel. And there's good reason for that, because it's the very best arbitrators are there, but arbitrators who have a very good knowledge in sporting disputes. As we'll see when we get to dealing briefly with how Olympic arbitration is conducted at the Olympic Games, there's very sound reason for that, because you need people who are not only expert lawyers but also expert in international arbitration and who understand sport at the international level to produce fast and effective binding awards. CAS proceedings conducted privately, but the awards are public. We've dealt with that. If you're dealing with a CAS appeal, one of the great things about a CAS appeal is you have a de novo hearing. So you have a total start-again rehearing. But bear in mind, one of the risks you have is that sometimes parties will agree just to go straight to the appeal phase, to bypass the preliminary arbitration, to keep costs down. But bear in mind that when you're conducting an arbitration, there is always a right of appeal. So therefore, care should be taken in drafting witness statements that have to be prepared in CAS proceedings, and also some real thought needs to be given as to how the evidence might unfold. Especially how it's unfolded if you're lodging an appeal. If a witness hasn't quite come up to proof or might have strayed from their proof of evidence, you'll find that because you are having a hearing de novo, it's not as though you can explain the evidence away and say, well, the inferences might flow another way or not. It can be far more devastating for a person on appeal because of the hearing de novo, because suddenly they'll have to get back into the witness box, give evidence again, and their earlier evidence can be used against them as a prior inconsistent statement to discredit them. So, very important in determining and making the decision whether or not you're going to lodge an appeal, because appeals in CAS are hearing de novo, and it carries a whole new raft of forensic decisions that you need to make as counsel acting in these arbitrations. Finally, costs. We could spend an entire seminar on dealing with CAS costs, but we won't. Suffice it to say, they're discretionary in terms of the parties' costs. One looks at the complexity, the outcome of the case, and the financial resources of the parties. Traditionally, it's a low-cost jurisdiction. To give you an idea, I've used two cases there. When I appeared in the Mark French case in 2005, I won't say how much his fees were, but it was a tour de force that was fought at first instance, which we ultimately prevailed upon on appeal. At that stage, the highest ever award in CAS was about $18,000 or $19,000. We got $40,000 back on costs. Wasn't bad, but it's still that was a world record, and we got $40,000 back. It didn't come close. We broke our world record in Marinov and Asada in 2007, where Mr. Marinov got $80,000 back. Now, that world record has been smashed since then, and it's not something, look, it's good for lawyers to be a little bit glib about and a bit wry about, but at the end of the day, this is becoming one of CAS's real problems, because it was initially set up to be a fast and low-cost jurisdiction, and it's now becoming prohibitively expensive from a whole host of reasons. And that obviously comes when lawyers become involved, given the amount of money that's involved in sport. But it just gives you an idea that in terms of cost, while it's a low-cost jurisdiction, and that was the idea with which it was with which CAS was set up, it's moved considerably away from that in the last decade. 30 years on, we've seen an enormous number of cases through CAS. In 1986, there were 2 cases. I've jumped a few years there, but the last 10 years is informative. And this is a really exciting time to be practicing in this jurisdiction. You look at 2002, 86 cases. 2014, the official results haven't been published, but Matthew Reeb assures us that there's been well over 400 cases heard. Matthew Reeb is the Secretary General of CAS. There's been well over 400 cases that were heard in 2014. It's only getting bigger, so this is definitely a jurisdiction worth paying attention to. We've dealt with the issue of costs. Obviously, costs are now very much weighing down CAS arbitration, but compared to the problems or the challenges, I wouldn't say they're problems, but they're certainly challenges that CAS needs to address on a day-to-day basis. The ad hoc division of CAS, the way it operates at the Olympic Games, is impressively swifter and more economical by comparison, as we'll shortly investigate. So what's the future for CAS? Well, the question has to be asked, given the cost, is it sustainable in its current form? Costs play a very big role in that, and certainly bearing in mind how it is that appeals are conducted on a de novo basis. My view is that this has opened up an opportunity for regional sports arbitration panels to hear sporting disputes at first instance with a limited right of appeal to CAS, if these arbitrations could be efficiently and affordably conducted, and hence the evolution of the idea of MSAT, which Tunku Imran addressed. It was through the experience of seeing how CAS had strayed from its original objectives that a lot of athletes at a national level are getting left behind in the cost and the size of CAS arbitration. National athletes, these sporting disputes are important to them, but not everyone needs a G5, hopefully, or a Gulfstream 5 in terms of a jet, which is what CAS has sort of become. National athletes, I'm sure, will be quite happy with a 6-seater Learjet, which will still get them from A to B very comfortably, much more fuel efficiently, and do the same job but without the considerable overhead in terms of price and logistics. Noted, Tunku. But so what does that render CAS? My view is, I think, and this is just my personal view, looking at where it's come from and where it's going, I see CAS as being purely an appellate court in 10 years' time. And hopefully Malaysia will lead the world in showing that having centralised sporting tribunals, it's crazy having 20 or 30 domestic tribunals with people of various levels of expertise deciding what are characteristically the same types of disputes. Now, we can understand why that's happened, because this body of law has only just really evolved over the last 30 years. But it just seems that the time is right for there to be a central sports arbitration tribunal such as MSAT with a right of review or appeal, but a more limited right, in the same way in which you'd have an appeal or a hearing to a court, whereby you can't have a hearing de novo in state courts, but you have the traditional rehearing appeal where the court looks at the evidence and the inferences and whether or not there's been legal error and the like, which will go a long way towards containing costs both at the first instance end, but also making CAS more affordable. And to me, that's where I see the future of the Court of Arbitration for Sport. Many may differ. In fact, I might write a paper about it and see who comes out to challenge me on it. That's a good way of testing your ideas, often ending, or can sometimes end with brutal consequences. But it's an idea, I think, it's a discussion, I think, that's certainly worth having. All right, very quickly, I'm not going to be too much longer. I'm going to be about 5 or 10 minutes. Looking at crucial procedural considerations. I'm going to look, firstly, at appeals in CAS. This is just a quick overview of the types of things you need to be familiar with about the CAS rules, because there's quirks in them. And you need to be aware about the different quirks in these rules when you're conducting this arbitration. Normally you have 21 days to appeal the decision. However, often each of the different rules and regulations of the sports organisation incorporated by reference into the sporting contract, they may say something different. But if they're silent, you're stuck with 21 days under the CAS code, because if the parties have agreed to conduct the appeal in CAS, it invariably encompasses the rules of CAS as well. That's how we get into the CAS rules. Compliance with directions in order of procedure. For those, I don't know what it's like in Malaysia, but I can certainly say this, although it's changing now, I think in Australia and the United Kingdom and New Zealand, many judges complain, especially those conducting the commercial lists, that directions for the parties or timetabling are often honoured in the breach, more so than they are in the observance, in terms of timetables and compliance with filing submissions and witness statements and the like. Not so in CAS. It's a Swiss creature. And so time and being on time is vital, as Benoit will assert is very important to being Swiss. And so that aspect of Swiss culture has spilled over into the way in which CAS proceedings are conducted. So bear in mind that these aren't just guidelines or suggestions. As we'll see in a minute, they have disastrous consequences if not properly observed in terms of timing. The form of application, when you file your application on an appeal, I'm just dealing with an appeal here rather than going into too much difference between first instance and appellate procedure. For the convenience of discussion, we'll deal with the appellate jurisdiction, not the ordinary jurisdiction of CAS. You need to properly state the basis of the application and the grounds of appeal for it to comply with the CAS rules. So how you frame your appeal is vital so that the appeal can be considered a valid appeal. Otherwise, you'll lose your right of appeal. Filing fee, you have to pay, I think it's 1,100 Swiss francs on filing. And then very soon thereafter, you'll be required to pay in advance on the costs of the arbitration. CAS is very efficient in following that up with the parties. And then likewise, you'll see the language of the arbitration is dealt with also at the time the appeal is filed. We have a problem here. Our computer is frozen. Well, I don't know if we can have a techie sort that out in the meantime, but we'll move on. In addition to that, decisions then have to be made as to whether or not there we go, we're good, all sorted, as to whether or not the application is urgent and whether or not there needs to be interim measures. So have a look at the provisions, both relating to the ordinary and appellate jurisdiction in dealing with interim measures. No different to the types of things you would as a commercial litigator if you need to go out and obtain some sort of injunctive relief to preserve the fruits of your victory or application. Next, governing law. In the absence of the party's choice, it's Swiss law. And this is to deal with the substantive dispute. Obviously, Swiss law applies to the law of the arbitration, given that Lausanne is the seat. But if the parties in their sporting contract haven't set out what the governing law is of the substantive issues under the contract, then the default position is Swiss law, or that's for the ordinary division, and in the appeal division, the law of the country of the domicile of the international federation, which will usually be Switzerland. Or alternatively, as the panel may otherwise consider appropriate. So there is a discretion there for the panel, but obviously that panel has to be exercised judicially and enlivens, as it would in any commercial arbitration, if you saw that clause there, the opportunity for the panel to consider jurisdiction on forum conveniens or non-conveniens grounds. The form of the hearing is set out pretty clearly. Note that in terms of doping cases, the standard is comfortable satisfaction. In other words, it's a little more than balance of probabilities in terms of proving the offence, but not as high as beyond reasonable doubt. Somewhere in the middle, but obviously for the allegations to be considered proven, the arbitral panel needs to be comfortably satisfied. Authority for that proposition was in the case of French, which has been since affirmed in dozens of CAS arbitrations. And finally, the form of the award is dealt with there in Rules 46 and 55 accordingly. Time limits are vital. If you don't file your statement of appeal and appeal brief, then the rules provide that the arbitration shall not proceed if it's not filed in time. You get one extension, but that application for an extension must be made while the time is still running. If the time has expired, obviously it can't be granted, because under the rules, if that brings about an end to the arbitration, the arbitrator has no jurisdiction. Likewise, where a party hasn't paid the entire costs, in other words, the CAS advance on costs of the arbitration, where CAS will write to the parties very early on and say, we want you to pay 5,000 Swiss francs each to cover the cost of the arbitrators, or however much it might be. If those costs are not paid, then the request to, or the appeal shall be deemed withdrawn, and the CAS shall terminate the arbitration. In the case of Budel-Velnick in 2014, published award, the CAS arbitrator declined to accept jurisdiction, and that hasn't been disturbed. It's considered by many in the area as a very sound decision because of the new wording of Rules 48 and 51 of the CAS Code, because the appellant was 3 days late in filing the appeal brief. As a disastrous consequences as to how appellant's counsel would have explained that to his or her client. Recently, the Swiss Federal Tribunal declared that an arbitrator properly declined jurisdiction where the appellant did not pay the advance of costs on time, holding that the termination of the arbitration in such circumstances would not offend procedural public policy under Swiss law. So again, these advances on costs have to be paid, otherwise the arbitration risks being terminated. However, recently, as in a month ago, a CAS arbitrator in Australia, I was on the losing side of this argument, but I'm not sure whether this case will finish here. But currently there's an Australian decision. Justice Emmett of the Federal Court, who is sitting as an arbitrator in this case, held that where an arbitrator accepts jurisdiction where a party declined to pay its share of the CAS advance, the arbitration, on his reading of the rules, would only be terminated if the entire advance wasn't paid. So there's two ways you can read that Rule 64.2 provision. So it runs contrary to the previous two decisions, but it may well continue to be a matter of controversy once the substantive arbitration is completed. The Olympic Games division, we're nearing the end here, it operates on 10 days either side of the Olympic Games. So once you have that window on either side of the 10 days either side of the Olympic Games, sporting disputes are determined by the ad hoc division of CAS rather than its traditional or usual operation, and that's because of the speed with which these disputes need to be dealt with. And what happens is, before each Olympic Games, the Court of Arbitration for Sport puts together a special list of arbitrators who are available to hear sports arbitrations at short notice during the Olympic Games. For instance, the case of Yang and the Federation International Gymnastique 2 Olympics ago, which was a case, 3 Olympics ago now, which was a case involving a calculation error and the extent to which the second-placed gymnast, a Korean, could have appealed, or whether or not had properly agitated his right of appeal over the winning American gymnast due to a computation error on the part of the judges. That's the type of case that falls into a game rule case. The Korean gymnast was unsuccessful in that case, and I won't go into the reasons for it, but it's just to give you a bit of a flavour of the types of cases that have to be dealt with quickly in the course of an Olympic Games. Likewise, eligibility decisions, selection cases, and the like have to be dealt with very quickly so that people don't lose their right to participate, which for many is a once-in-a-lifetime opportunity. There are provisions there to stay and take interim measures in extremely urgent circumstances. Interestingly, what informs the balance of convenience and whether or not a stay is exercised on the part of arbitrators is obviously the irreparable harm to the applicant and whether or not the fruits of the application would be considered nugatory if the relief wasn't granted, as opposed to an interesting proposition which really gives a very large scope of counterweight consideration to the tribunal is whether the interests of the applicant outweigh the interests of the Olympic community, which could allow for a very broad scope on the part of an arbitrator refusing the relief. An arbitral decision is ordinarily required within 24 hours of lodgement of the application. This is what makes Olympic arbitration fun. Arbitrators generally not only are required to be expert in sports, arbitration and law, but are also required to have the stamina of a marathon runner, as are counsel appearing in this jurisdiction. And when it's on, it's on. So you need to think and work very, very quickly. In these arbitrations, I've never been to an Olympic Games and participated in one, but many of my colleagues have. And as Tunku Imran, who's had experience seeing this in operation at many Olympic Games, they operate around the clock. So it's really fast track. The arbitral decision, a written decision is required. So this really requires, this is a really challenging exercise and briefly reasoned, so that it can be enforceable immediately and there's no appeal. So this is a fabulous jurisdiction if you have the stamina and the knowledge to be able to cope with it. CAS arbitration costs are free, so you're not going to have to worry about an advance on costs during the Olympic Games, 10 days either side relating to an Olympic dispute, and the parties bear their own costs, so there's no argument over costs or anything like that. While it says the parties bear their own costs, in most CAS arbitrations it'll often involve a National Olympic Committee, and so the National Olympic Committee will be paying the costs given that it has an interest in it, and will usually in some way absorb the cost of the athlete. In fact, if a lot of the time the athlete's cause will be pursued by the National Olympic Committee, and most National Olympic Committees now travel to an Olympic Games with their own team lawyer, either from their own domestic country or they'll brief somebody from another country who's expert in the area. But it's a sad but realistic state of affairs now that just like the team doctor, the team lawyer now goes along with the team for the National Olympic Committee given this jurisdiction. Finally, arbitrators and counsel are on call, and as we've seen, these arbitrations take place at breathtaking speed. In fact, Olympic sports arbitration should be an Olympic event in its own right when one looks at the Any chance of that, Tunku? We turn to whether or not there's an accessible body of sports jurisprudence. Well, that's a real challenge in terms of looking at sports law and sports resources. I'm very lucky in many respects because I've built up my own private library after 15 years of activity in the area. So I have a very good private library all on my hard drive, so it goes with me everywhere, and it's maintained and regularly updated. So I'm lucky I can have it at my fingertips, but that's only because I've grown up with the area. And one of the real challenges is to stay appraised of this rapidly evolving area of law. How do you keep up with it? Where do you find it? And we had this really unsatisfactory circumstance until recent years that it's almost like this closed shop of societies, this secret society of sports arbitrators, and you can imagine them sort of, Hogwarts style with a cloak and a hood. Do you have that decision? I heard about a decision a few months ago in Bogota. Do you happen to have that decision? Yes, I do, as a matter of fact. And swapping cases and decisions and building their own private resources, it's entirely unsatisfactory. And in response to this, it took a while, but CAS ultimately agreed to start publishing awards on its website, and so it's a really good step, and we've come a long way, and there's an index where you can search decisions, and it's much better now, but there's still a long way to go. Now, there's no law of precedent in the CAS jurisdiction, but this is the good thing about publication of arbitral awards in an area where people all need and benefit from playing by the same rules. The classic case and example is the time limits cases we've just seen. Ultimately, cases on time limits in the next 3 or 4 years will be reconciled. There'll be various instances of this happening, and you'll finish up with a settled line of authority as to how these types of disputes should be addressed, and using time limits as an example. And so it's a good thing. And while not bound, there's no binding. An arbitrator is not bound by the awards of the appellate division or previous arbitral awards. It is very persuasive, and even more persuasive when you see some of these very heavy panels. You know, if you have a panel of Gabriel Kaufmann-Kohler, one of the world's leading international lawyers, Jan Paulsen and Michael Beloff, declaring what a particular legal outcome should be, nobody's going to argue with it. It's every bit as persuasive as a senior appellate court of any state. Obviously, the availability of sporting rules is very important in terms of access to justice and fairness and the like, so that people participate in sport in accordance with the same set of rules. Where do you get these resources? I've included them there for the various websites and the like, where people can find them. At the very bottom is the Australian-New Zealand Sports Law Journal, of which I had the privilege of being the founder and editor, and still the editor of. So we try and, to some degree, rope together all of the relevant jurisprudence and make it available for people, and certainly it's available through anyone who can join ANZLA. And likewise the different websites in terms of regulation and case law. So in your hard copies of the papers, which I think will be available on the website, Faris, is that right? You'll be able to follow those links and at least have a start towards finding some of the jurisprudence you're looking for. There's been a recent increase in challenges to KAS awards. Article 190 of the Swiss Federal Code on Private International Law sets out the very dry grounds upon which you can challenge an award, and what you will find is it's no different to any other form of commercial arbitration award in Switzerland, challenging a Swiss arbitral award. What is interesting is the last ground, Swiss public policy. The award is incompatible with Swiss public policy, which gives some degree of flexibility on the part of an appellate court to cure or frame an outcome which it considers or perceives to be unfair. I've never fully understood Swiss public policy. Perhaps Benoit might be able to tell us a little bit more about it in due course, but it seems to be, it gives one a very interesting insight into Swiss culture when you read Swiss Federal Tribunal award or Swiss Federal Tribunal decisions where awards are being challenged on Swiss public policy grounds. Finally, I'll just touch on that. That's, again, another seminar in its own right. The Claudia Pechstein ice skater decision in Germany, recently a KAS award was declared to be unenforceable by the local appeal court in Munich, the Landesgericht, I think I've said that correctly, given the nature of KAS arbitration. It was held to be, essentially, KAS had a monopoly, and indirectly there was no bargaining power between the athlete and the relevant international federation and German Olympic Committee, and therefore, as a consequence of that, the athlete didn't voluntarily submit to that process of agreement. The award was declared unenforceable. Methusalem, that's a very good example of an award being unenforceable under the Swiss Federal Tribunal, where KAS stayed the award because, again, it offended Swiss public policy and the curtailment of Mr. Methusalem's economic freedom. He was hit with a very heavy fine or damages to be paid to his former football club as a result of a transfer case. And because he didn't, or he couldn't pay it, FIFA then commenced disciplinary action for non-payment. They suspended him until the monies were paid. The only way he could get the money to pay it was if he played football. So he was in a catch-22. And on public policy grounds, the award was unenforceable. I won't trouble you with the enormous amount of fun we had in Victoria 2 months ago at the Australian Grand Prix with the Sauber case, but suffice it to say, it went right down to the wire. This was where the former driver for a Sauber, Mr. Vandergaard, won or had an arbitral award which declared him to be entitled to drive for the Sauber team. Sauber management had other ideas, and hell was going to freeze over before Sauber were going to let Mr. van der Gaard drive for their team this year. They had another driver ready to replace him. This was challenged right up until the eve of the race. So through qualifying, the race is on Sunday. The Supreme Court, the Supreme Court in Victoria should also be an alternative, or the resources of it be used for the CAS ad hoc division at the Olympic Games. This case was turned around in 5 days before Justice Croft, who delivered an amazing judgment. It's about 50 or 60 odd pages and impressively scholastic, as Justice Croft's style usually is. The Court of Appeal heard the appeal. That was handed down on the Thursday. Court of Appeal heard the appeal on... So the case started on the Monday, heard on the Wednesday, judgment on Thursday, appeal argued on Friday, Court of Appeal hand down decision on Saturday. The upshot of it was the arbitral award was upheld. It was not set aside, notwithstanding the comments of one or two Sauber executives, which some considered to be in contempt. They left the country very quickly, having expressed an intention that Mr. van der Gaard would not be driving in the Grand Prix, but the upshot of it all was that the parties unsurprisingly settled at the 11th hour, and Mr. van der Gaard didn't drive in the Grand Prix on the Sunday. But again, Justice Croft's decision is well worth looking at in terms of enforcement of arbitral awards. Finally, as we've discussed, fairness and the foundation of fair play and transparency is essential to sports arbitration, which should be accessible to all who participate in the sporting contest where there are sporting disputes. And accessible is not only in terms of geographic opportunity, but also in terms of cost and access to proper resources to properly have your day in court if needs be. And that's not just for athletes, that's for sporting federations as well. Sometimes small sporting federations who have problematic people to deal with and don't have much money themselves also need to have access to governing their own sports to ensure that everybody else participating in that sport is able to do so fairly. Sports arbitration practitioners, as we can see from all of the different procedural considerations that need to be taken into account and the types of things you need to be alive to as sports arbitrators, play a vital role ensuring fairness and just outcomes for everyone involved in the process. And hopefully this morning's kit bags that we've quickly ruffled through and found bits and pieces there that might assist us in the management and conduct of sports arbitration will assist us all in lawfully enhancing our performance in this area of legal endeavour and practice. Thank you very much for your attention and time this morning, and hopefully that's given you a good overview of the mechanics of sports arbitration.